So my name is Julie Pouch, and I'm the attorney that runs the Education Pro Bono project. And so this is the basics of education advocacy and for special education. I'm not going to be talking really about discipline today. We're going to have a second training about discipline issues on October 22nd at like 2:30 to 4:30. I'll send an announcement on our listserv, and it'll be on a layout too. But it's that's going to be more on the safety issues, and it will cover a little bit of special ed related to discipline. But we're trying to just focus on IEP process today and basic special education law. So for special ed, a lot of our cases are about IEPs. I'll kind of get into that. I'll get into that a lot more, but that's most of our cases, and they're clients with all sorts of different issues. You know, whether they want different services or they want a new school placement or you know, an IEP for the very first time. Okay. And we're going to see cases with all different types of disabilities. You know, common ones are learning disabilities, emotional disability, you know, ADHD, OHI. I have a question? Yes?
Sorry, what does IEP stand for?
Yes, I'm definitely getting to that, but it's going to be individualized education program. Okay, and but that's so there's lots of different disabilities that that the law cover. I mean, any kind of disability that affects you is going to, you know, be covered under the special education law. So let's just get right to that because. So first, LAF. Here's kind of where we fall in children and family, and this is a pro bono education project, and we refer a lot of our cases out to pro bono attorneys. Sometimes we take them in house and as well, and these are low-income clients. Okay, so these are all the clients that qualify under 125 is 125% of the poverty level. So, and then we also represent DCFS boards in-house. And then Kate Gotts is just going to talk to you like right after the break just about her school closings project. Obviously, there's been a lot of school closings in CPS, and she does a lot of the cases herself, but she also is interested in working with pro bono attorneys, and occasionally you're going to see those pop in as well, a school closing case and working with Kate. You know, these are the types of cases we handle, special education. Like I mentioned, we also do discipline, like a straight-up expulsion, but a lot of times that also involves special education. Residency, we did an advanced training for that this past summer because we do have some where, you know, you're going to the wrong school district or there's enrollment issues and things like that. We do things with school records, bullying, things. So here's the kind of overview of our team. You know, we have Kate Shank. She's volunteer services, and she's kind of working over the pro bono project. Ashley, who's in the back, Ashley is our supervisory attorney. She just coordinates the whole thing of everybody. Rich is over her, and Rich is like, you know, if there's a big case or something like that, you might hear from Rich on that. So, and then Steve is a staff attorney here. He's not here today because he's already been trained, obviously. And then Verity, Zoe is our paralegal. Kate, I mentioned, is going to be coming in. And then I put this attorney because I'm going to be leaving in November. But so you'll meet somebody new. But my name's Julie Pouch right now. That's me. And then we also have some in-house volunteer attorneys. Don, put your hand right there. And then Ellen as well. There she is. Okay. That's our team. Okay. And so the pro bono panel has over 100 attorneys, and everybody comes from really different backgrounds. And so some people are personally interested because maybe they have a family member or somebody that friend that they know has a disability, or some that are just really interested in kind of breaking into an area of law. We have solo practitioners, we have people from firms. Some people are just retired, you know, helping out. So I'll add you to the email list, unless you don't want me to, don't let me know. But and then what we do is we send out cases, and then we just ask that you take one case per year, and some of them are a short commitment. Which are like, you know, Crystal can tell you she did a couple safety ones where you just write a letter and you know, get the kid, you know, maybe a safety plan or get them back into school, something like that. And some of them are a little bit more of a commitment, like a due process hearing, so maybe a little bit longer. And some of the breakdown, I think, would be in the pro bono manual. But so I'll send out the referral email, and it's just kind of there's a sample in there, but it's basically telling you everything that's been going on in the case, the facts, and kind of tells you the next step. and then you would email me, and we would do a conflict check. Sometimes it's really simple, and sometimes not. And then you conference with me and see if it's a good match, and then the volunteer attorney agreement, and then I send you all the stuff. And then you can meet with the client. There is space available here, so you just let me know if you do need space, or if you have your own office space, that's fine too. And then, the options as far as how it would work with you is basically you can co-counsel or you can lead counsel. And it's really up to maybe the case or your own skills or what your time is. So it really just depends. And so, when we have our conference, that's something that we would talk about, what you feel comfortable with. And, I co-counsel on a lot of cases here and just make sure to, keep me in the loop, obviously. It's really important if you're a co-counsel. Co-counsel before other things important. And then just, maintain client's file. And then we also have a practice manager system. And I would send you all of this in an email about detailed instructions. Okay, so the good stuff, right? So education law. So I'm mainly talking about some laws that affect our special education students. So can anybody name a law that affects special education students? Yeah. Any other law?
Section 504.
Yeah, great. So I'm gonna start with one that we probably don't deal with as much, but I'm gonna start with it. Hold on. We talked about all the acronyms, right? And I already did one. I did it already. I'm going to be using a lot of acronyms, and feel free to raise your hand and let me know if I do it and you're not understanding what it is. There is like a little handy guide in the pro bono manual that kind of goes through some of them. Like IEP, 504 plan, BBED. These are all like eligibility categories. So specific learning disability, behavioral disability is not like an official one, but people say that. Emotional disability, emotional disturbance. So it's just, there's so many acronyms in education law just in general. And so today, don't feel afraid to do that, but I'll keep that in mind as you're reading through stuff because it's really common. And so, okay. So this is a law that we probably don't deal with a lot, FERPA, but this is how we build a lot of our cases, especially here, because our clients, they're not in the classroom, right? They're coming in, they're hearing from their kids maybe what's happening. They've been to the meeting, and a lot of our cases are built through records. So we're reviewing records, and there's no discovery in special ed, like hearings and things like that. So we are asking for the records, and under the law, you have the right to all the records. You have the right to review them under FERPA, and its counterpart, which we actually like a little better around here, ISRA, the Illinois School Student Records Act, and it gives you access to all of them, so that parent, and this happens a lot with our clients too, where they'll say, they won't give me any of the records. I've asked and things like that. This is important to know that even just advise your clients, like basically, you have rights to all the records, and obviously, you guys all know this, if you're lawyers, if you've worked on legal stuff, put it in writing, the requests and things like that, because they don't always maintain it, they don't always know the parent asked for records. So this is important to building our cases, and there's some other rights that come along with it. Right to consent to disclosure of personally identifiable information, so the privacy aspect. There's a lot of issues with our clients is that teachers are sometimes sharing things with outsiders. We had a client come in yesterday where they talked to the counselor without a consent. That's really important. Why you should have a consent with your client or to release information, because the school really should not be talking to you unless they can release that information legally, right? So that's a big thing with our clients too. And it's not something that we are litigating over necessarily, but it's something to know that they do have that right to privacy, so they shouldn't just be willy-nilly with this information because it is important to keep. So, okay. Section 504 we talked about. This is the federal anti-discrimination law. It applies to all people, so it's not just in schools, but we're using it mostly in schools. So it prohibits discrimination in any program that's receiving federal money. And so, most of our cases are public schools, so they're getting federal money, okay? But, on occasion I've had private school, and it's kind of a hunt, honestly, to figure out if they're getting federal money. And you want to think about maybe Department of Agriculture, they get the free lunch, or books sometimes. So it's a little harder in that situation, and it has to be kind of more substantial. It can't just be like a tiny, you're getting, $1,000 or something like that. It has to be much more substantial. So, again, we're not running into that a lot, but And this is a 504 plan. So this is like, kids that, not going to be talking a lot about the 504 plan takes. We don't have as many cases with that. But really what it is, it's annual education plan, similar to the IEP, but this is providing accommodations and modifications in order to remove barriers. So it's about equality, okay? And we do use 504 even in our IEP places because it's giving that equal opportunity, okay? And so accommodations, and modifications and maybe extra time, or if they have asthma, sometimes you'll see in a 504 plan for asthma or seizure or something like that, where it's like 504 is basically if you have a disability and it affects a major life activity. So here it's learning, right? So a lot of times with 504s, it could be they're not exactly hard to get in a lot of the school districts we work in. If you have a disability, you bring documentation of that, and they're going to see how they need to accommodate you. And so a lot of times with ADHD, maybe where it's not affecting them so significantly that they're going to have bad grades or miss school or be so distracted they can't do their homework and things like that. But maybe they just need a little extra time for, that's going to help them with SAT and things like that. So, but it is helpful too with our IEP places. Okay, here's the biggie. This is IDEA. This is the Federal Special Education Law, and it applies to children between the ages of 0 to 21. So 3 to 21 for most of what we're dealing with because that's Part B. And it's for people with disabilities who need specialized services to benefit from education. So this is the IEP, Individualized Education Program, and it's individualized to meet child's unique needs. Okay, so individualized, unique. That's the whole point. Okay, because every kid, you want to make sure that it's all tailored to their needs, and that's kind of the whole what the law is built on. That that these kids aren't just kind of being shoved aside and forgotten, that they're really working on their specific needs. Every kid's really going to be different. You're really going to see that too. Maybe one kid that their specialized services they would need would be reading instruction. That's a really basic one, but they're going to need that specialized methodology that is not going to work for a lot of other kids. So it's really about, I'll often use the word learning differences because it commonly is that, especially with learning disabilities. They just really maybe they need a multi-sensory approach where they're tapping the table to sound out words and sounds. So it has annual goals, it has the services that I was talking about, and the support. So it could be like a paraprofessional and things like that. But that's a big guy. And so here's just kind of what I was talking about here, where 504, they do not necessarily need specialized services. Not saying that there can't be specialized services in a 504 plan. I've seen that we're more related services like an occupational therapist working on handwriting or something like that. Social work, I've seen that. It's not as common though. So if you really need a service, you're going to have usually an IEP because that's what you need to make progress. And the IEP eligible children need specialized services, but also they're going to need accommodations and modifications. So they're still getting, 504, and that still applies to them to make everything equal. But it's not, 504 is not the same. You don't have 504 plan and IEP at the same time. I get that question a lot from parents. You don't have that sometimes. Okay, so here's Illinois law. It is largely the same. The school code applying to special ed, but look at the timelines. That's really different. Just 60 school days for evaluation, or in federal law, it's 60 days, I believe. So it's just obviously I'm paying attention to the Illinois law because that's the timelines are they're gonna be what we call it. So and like I mentioned, this School Student Records Act. This is a more expansive definition of school records, and it's 15 school days, which is a shorter amount of time than FERPA. Okay, so we like this a little better too because it's including a lot more.
What does it? You said it's a more expansive definition. Mm-hmm. What does it include that the FERPA disclosure wouldn't include? What do you get extra?
It's the. I don't remember. There was. I can't recall exactly, but there was one thing I was coming across. It's just very, very inclusive. So I apologize exactly.
It's maximally inclusive.
Yeah, because Israel has the only exclusions it has. Ashley, you can correct me if I'm wrong. She did a training on this before, but it has a video. You can't get video for security video. from Israel. They're specific about that.
They plan to use it in
Yeah, if they unless they plan to use it in discipline hearing. And then with the other thing we can't get is, I can't remember, but like FERPA, there's a lot of, if you look on their website, they have all the decisions from their body that looks it over. And they definitely exclude a little more than we do. So, and you're contacting the federal government and going through a proceeding to find it, to get to qualify them. Here we take it to court. So, which is also better too. Okay, so here's we're going to go over the IEP process, which is where most of the action happens. Okay, so the 6 principles of IDEA, and this is kind of what's happening through all of this. Is everything that you're arguing is all kind of based on this. So the free, appropriate public education, we call it FAPE. That's another acronym, right? And basically, what it is it's the floor of opportunity, the basic floor of opportunity. That's Raleigh. That's the case, the seminal case here, to make meaningful educational progress. Okay, so what's appropriate depends. Again, it depends on the individual child, but it is, you're giving them the opportunity that they can make progress. So another principle is the appropriate assessments. We'll be talking about those too, because to find out what that child needs, you need to look into it. You need to assess their needs. You need to find it out. We talked about the individualized education program. We need to follow their progress. We need to, more than other students, special ed kids, a lot of kids with special needs, it's hard to teach them, right? So if you're not following their progress, they could just sit there and I've seen that many times with kids and clients, and they haven't made progress in 6 years. They can do the same thing, especially kids with maybe undiagnosed things or because they haven't been properly assessed. Least restrictive environment, or LRE, one thing we say, and that is basically that students should be with their peers, non-disabled peers, to the maximum extent possible, with supports and services. So LRE, this exists basically because, there's a long history, you can read about it if you want, but it's basically because before special ed laws, kids weren't going to school. They were kept at home, they were in institutions and things like that. And so that's why, and this is actually something with some of our older attorneys that have volunteered for us. They never even had access to special ed kids in their schools. Special ed kids weren't in their schools. And so, and it's becoming more and more inclusive, but that's the preference in the law, is that with, kids with special needs are going to be educated with the proper services to support them so that they can, be with everyone. There's no reason they should be separate if they can, receive an education. So parental participation, and we'll talk about a lot this today, and that's why if you're going to volunteer with us, that you're going to help them participate too, because that's even part of it, is a lot of our clients never feel like they're a member of the team, and they never feel like anybody hears them or listens to them, and that's just a really, really important part of representing or being an advocate or an attorney for one of our clients, especially because they just have never had that. And, even if you're not accomplishing everything that they want in their goals, even just having them be heard is something maybe they haven't experienced. And it is a major part that's envisioned in the law. And then procedural safeguards, there's a lot of things built in to make sure that schools are, following this law, notice that parents have notice of the meetings, or that they have the right to appeal an administrative due process hearing, the team's decision. So that's kind of the basics, and you'll kind of see them pop up today and as we talk about the process. So here's the IEP eligibility process, and we kind of go through this. This is envisioning from the beginning, but even after you're eligible, you're going to go through 2 through 6 every 3 years, okay? So, after we've done the referral and they're eligible, you're still being reevaluated every 3 years, so that's why everything in the process is important. So, and this is kind of another thing I just kind of put at the beginning because, again, 2 through 6 is this multidisciplinary team. Everything in IEP is team, okay? And that's the idea of the parental participation. It's not somebody, well, in practicality, maybe it is somebody from high above making the decisions, money, right? But the idea is that everybody in the team is participating, and that's why I really try to engage people when I'm at an IEP meeting, different people on the team, see what they think. You know, if there's a question about eligibility, what does the special ed teacher say? You know, like, has she had any interactions with him during interventions or something like that? Trying to figure that out. So I've started the ones that are required, but it really should be anybody that has any relevant information about your client's child. So if your child, the child receives speech therapy, that speech therapist should be at the meeting. We'll talk more about that kind of stuff later on, but, you know, and then also inviting that outside support. You know, say, you know, maybe if you're just even like advising your friend or whatever, you're not able to come to be an advocate or attorney for the client, or for the person. You know, having that outside support, I tell that to parents when I do parent training, you know, therapists, doctors, sometimes having just that, having an extra friend, or a friend, having an extra friend is just, it's beyond, it's so helpful for the parent, you know, being able to participate fully. So, and gosh, bring doctors if you can. If they're willing, oh my God. It's just an incredible little team going on with, you know, making the legal arguments and they're supporting with medical backs up.
Do you bring the doctors to the first one?
If there's already, I mean, usually the parent hasn't been getting things for a while, and that's, yeah. So I'd definitely bring like, doctors that call in is another way to do it.
Yeah. I know the law in Illinois changed recording. Where are we? Most school districts tell you can't record IEP meetings. Where are we on that? Or
I think with eavesdropping law, they did put something else in place. There was like no law for a while.
Right. Well, there was a law, and then there wasn't a law.
If you do ask, I mean, you have to provide notice because then they have the opportunity like to tape as well, which is that's happening before where my client wanted to tape, and they wanted to tape as well, so we were both taping, which was funny. But I mean, you know, so you can't just eavesdrop. You have to give them notice. I'm pretty, you know, I don't know as far as the new law. I'm pretty sure you have to give notice. You can't just hide it under your.
No, I didn't mean that, but I was just wondering if they're required to, even if you give notice.
I don't think they have to let you. But if you have a disability, that's potential too for accommodation. But I mean, we're kind of getting into it. But
oh, sorry.
Usually, I mean, I take notes, and so I don't really record because it does put the team on edge a little bit, and I like them to be open. So, okay. So here's the first step. Related to the referral. This is kind of the basic of child find. School districts are responsible for actively, don't blame it, they can't blame on the parents for not making the referrals, for actively locating, identifying, referring for evaluation and evaluating all children with disabilities in district boundaries. So even kids that are at home are, you know, they're supposed to be doing screenings, and there's lots of things in place that they're supposed to be doing to make sure all the kids are found. So it's, that's kind of the first thing. So this is what you're looking for if you ever get an eligibility case. If you ever get an eligibility case where you're thinking, well, does this kid need an IEP? Should they be evaluated? These are some of the things you should be looking for. So, you know, some of the things are maybe a little more obvious, like missed milestones. Like if they're really little, like, you know, are they walking on time? Are they speaking on time? Are they like fine motor on? And even that's kind of clue for some things. If they're not speaking on time, and then later they have problems reading. Bingo, you know what I mean? That's a lot of big things with learning disabilities. It's a language-based disability. So if they can't speak when they're, you know, 4, that'll kind of clue me in. I mean, it's not like I'm not gonna like get in and say, oh, he didn't speak at 4, but because it still has to play a role in his education now. But it is a clue. Difficulty concentrating, understanding what is being taught. I talk to kids too, and about this, and they'll hear. I don't hear what people are saying when they talk to me. It just goes right up my ear. It could be some sort of auditory comprehension thing. So I mean, there's lots of different things like that. Behavioral issues. This is a big one. A lot of times they'll say, "Oh, they're bad seed" or something like that. But really, I mean, it could be an emotional disability. You know, and that's a big thing we see, especially with our clients, is they're being excluded from the classroom. So you know. Suspension, unofficial suspension. I'll get to that in my discipline training, but they'll have, you know, be just kind of kicked out of the classroom. They'll be sitting in the office, they'll be best friends with that clerk at the front desk, but they're not in their education. That's affecting you, and that could qualify you for an IEP because you might have an emotional disability. Diagnoses. These are pretty easier as far as, you know, if you come in with diagnoses of ADHD, bipolar, depression, that sort of thing. Medical needs. So sometimes kids, they're learning fine, but maybe their medical needs are to keep them out of school a lot. They're going to need a nursing service and things like that and support to make sure that they're remaining, getting that education even if they, have some sort of long-term medical need. Poor grades and standardized test scores. We just had a client come in yesterday where they had 4 years of apps never been evaluated. So that happens.
What was the medical? Sorry, when the so if you have significant medical needs that may require nursing services at school, is there also a facility for like school at home or in a medical facility if you can't?
Yeah,
medical
definitely. There's like homebound.
Yeah.
Sometimes you can qualify to get services at home. It's like 5 hours a week though, but you can make appropriate. You can make an argument that it needs to be appropriate. So obviously, that's like the law, but you can possibly get more. So homebound is like through doctors. It's not preferred obviously because it's the least restrictive environment. So requesting the evaluation, you should really put it in writing. Yes.
What's a CSE? Is that the same thing as an FIE then?
Yes. Okay. That's what we use in Illinois, case study evaluation.
Okay.
And so this is the federal full and individual evaluation. No problem. So we put it in writing, and I advise my clients to always put it in writing too, obviously, but it can be verbal, and that they should be responding to the parent. And then, when I'm writing one of these letters, I'll highlight all the areas of need that I think that, the client has, and or advise the client to if they're doing it themselves. And then, I support it usually, just to kind of avoid the denial and things like that, right? If the parent has preschool, if they're little, having their preschool teacher to the older, to the district, medical providers are obviously a huge resource. So after receiving the request, they have 14 days, school days, and if they determine it's warranted, they have to meet with the team and identify the necessary assessments and obtain parental consent to evaluate. It's all happening within 14 days. Not always in practice, not in real life always, but that's what it is. And then, if they determine it's not warranted, they'll notify the parent. They should be notifying the parent in writing, and it's the reason for that decision. Okay? Yes?
I notice it says school days, so if the request is made during the summer when school is not in session, does that mean nothing occurs until school starts?
In real life, yes. But there's, under like IDEA, a school day is,
Like a weekday?
it's a school day, but then also the summer does count for all. Yeah.
Summer school.
Yeah, summer school. Yes.
I actually just went through this. On the last day of school, I requested an IEP, or I requested a CSE on the last day of school, and my meeting is tomorrow. So, I don't know if it always works like that.
Yeah, and because the big district around here, they don't provide a lot of staff over the summer, and so it is hard. They used to have a summer assessment team to do a lot of it, but now it's not happening unless you're like in due process or something. So it's I definitely, if that interests you, we could talk about doing more compliance complaints. So yes.
Is there a procedural mechanism or some sort of hammer that keep them to the 14 days, or is it just something that?
It's something that will lodge on our due process complaints.
Right. But assuming you don't want it to ever get that far.
The compliance complaint. So we'll kind of talk about the conflict resolution, but the procedural, there's a pretty clear procedural errors. I think it is good to start doing that, especially with school districts that are doing it a lot. I see same issues happen. And so then the school, especially if it's happening all the time with different clients. Okay. So the domain meeting, a lot of people poo-poo on the domain meeting. I like it, especially with my law and compliance. This is the assessment planning meeting, okay? And so, like I said, what they do, they're identifying all of the tests that they're going to be doing, and all the different domains they're going to be evaluated. So the reason why I like this is it gives my client the first opportunity to say all the things they want them to look into, okay? And if it's not mentioned, they're not going to look into it, okay? Especially with certain districts. They just don't have the resources or that sort of thing. But they have to under the law. But it just kind of gets rid of a lot of the problems I think that that happen down the line if you kind of just nip it in the bud right away. So I like to go to these and I like to kind of have say what we want evaluated, take notes of everything you ask for and what they put in. And this is the key thing too. Again, with some of the districts, they do not send related service providers to every domain meeting. I always ask in writing if I have a concern about a specific area. So, for example, if I had a client for the client was blind and her daughter was having issues reading. I wanted a vision itinerant at the meeting. Okay, and they're not going to send a vision itinerant. They don't know the client's blind. So she had difficulties. The daughter had difficulties reading, connecting her vision to the paper, that sort of thing. A big one, but even like kind of more common one, I think, would be like handwriting. You're going to ask for that OT, the occupational therapist, to be there. You're going to ask for that speech therapist to be there. If you have reading concerns, I'm just going to say that right now. Reading concerns. If you have reading concerns, ask for a speech therapist to be there and get a speech therapy evaluation. Okay. Okay. Domain meeting continued. So, a lot of times these, like, again, they're trying to rubber stamp these, get these through. Review of existing data. I really do think it's important that they review existing data to determine what domains should be looked into. So, I mean, even if they're not doing it, still ask what they're doing and look into it. They are supposed to be, under the law, observations, looking at old evaluations. They can talk to the parent. They can do all this kind of initial screening stuff. They commonly don't, but it is good to point out maybe that they didn't. Additional data needed. So they'll make a decision based on review, but also on parental input. So commonly, they're not really like fighting the fact that I want a speech therapist, like a speech therapy evaluation, because my parent is saying why. But it's important that the parent, puts in their input and what their areas of concern are, and they should be looking. It's important not to add into the decision. So, let's see, and it's all different data to determine everything that's going to be in the IEP. And the disability, the eligibility. And then they're going to be doing records review, observation, standardized tests. Some districts don't like to be specific about that. They want to leave it up to the provider, or leave it up to the provider. And in some cases, I'm okay with that, but that doesn't mean that it says records review, observation, formalized tests, okay? It doesn't need to be that general. And I've seen plenty, and I've been at domain meetings where that's all they would write. But you can still push for certain ones. Like if your kid has autism, they really shouldn't have a language-heavy cognitive assessment, okay? Because they're not going to understand the instructions. Because if they have language deficits, So I mean, and this is like obviously with domain stuff. When you go to your first eligibility, you're going to understand a lot more about all the assessments they do. This is all through like personal going to it and researching. Because that's the thing about education law. It's a combo of education and law. I mean, you cannot do it effectively without, really trying to learn about education, about how to assess needs. And so I've done a lot of reading about psychology and things like that. And, even if I don't have a psychology degree, I took 2 classes, but it helps, it helps at least to start with the questions and things like that. And they'll explain it to you, they're good. I mean, the team members, they want to, so it helps to at least know the right questions to ask. Yes.
I know that I was trying to help someone, and with the domain, it was every time we knew what we were. I knew what I wanted, but once again I don't have that psychology background. Mm-hmm. But I could tell the way they kept writing the domain sheet. We ended up redoing it about 15 times, and I think their goal was to push it over the summer, hit the summer, because we needed observation, and we only had like 3 weeks of school left, blah, blah, blah. My question is there somewhere where we can get, it ended up some psychologist helped me with what was needed, but is there somewhere that you guys have samples that if you suspect like an auditory processing disorder, or you see that the child didn't reach his speech milestone and is way delayed in reading, that these are a combination of tests, or this is what should be on the domain sheet, that even if you don't list the test, this is what should be on the domain sheet.
I have like an ideal domain sheet. I mean, obviously it depends on the child, but again, it's the outside providers and resources, and it is a problem with our clients because they're not always connected to the right people. So I mean, if you do suspect your child, that your client, might need somebody else, you can call us and we can help, see if we can connect you. We usually will tell our clients to go to their primary providers and ask for a referral for specialists and things like that. And usually they'll help. The doctors will to, if they, a lot of times, especially the hospital ones, like one of our clients from Rita or University of Chicago, and they can make referrals to specialists to kind of support what's happening in the assessment. But obviously notify, if you do go to a domain meeting, notify the team that they're doing outside the assessments, because you can't use the same tool, because it will make it invalid. So, I mean, these are all kind of technical stuff, but, I think that's kind of, I don't have an ideal domain sheet, because it does depend, but I do like it to be specific, and then note what they say that they're not going to do. Okay, so they have 60 school days.
I have one more question.
Yes, sorry, to you, yes.
I just wanted to confirm that takes place after they have definitely agreed to do an assessment?
Yes. Yes. So, yeah, it's happening, if they agree, it's happening in the 14 days. So instead of getting the denial, you're going to get a notice of conference for the domain meeting. I've seen an occasion where they'll meet and then decide not to. I don't know. I'm kind of interested in that issue. I didn't think the kid was eligible based on what I was looking at, so we didn't go there. But it was interesting.
Is there something? I'm come from California, and there's something there called student study team meeting that takes place. So it would be really the first step after you request an IEP, where everybody will get together and really see what's going on with the kid, and do we need to do an assessment at this point?
That's actually what they're supposed to be doing during the review. I think they actually are allowed to meet without the parent and stuff like that, and do their screening and talk about that. They're not deciding whether they're going to do it or not, but they are gathering the information. Then they're meeting with the domain team and deciding.
Okay, because the student study team meeting, actually the parent is a really important part of that.
Oh, okay. I think that's the domain meeting.
So that's what I'm trying to figure out.
Yeah. I'm sorry. Yeah, I don't know.
It doesn't mean that they wouldn't necessarily agree to assess. Most of the time, they actually will not agree to assess.
Oh.
They're going to say, "Oh, we'll wait and see, and we'll try this intervention and that intervention. We're not going to."
See, here you'll just get either a no and verbal, and if that's not, you're not supposed to do that, or you'll get like the written denial, and that's they're supposed to put reasoning on it, presumably from the review, but we're not meeting and then not deciding not declining to do it. They're not. Almost. I haven't seen that very much.
Our district does what she says.
Really?
Because they schedule the two together.
Mm-hmm.
And
yeah,
and we get a lot of times that's what you get. It's exactly what she's saying. Where you know darn well that this kid should have an IEP, and instead they're just going to review, and they're going to do some more progress monitoring, and they're going to do some more. And you're getting that verbal.
To be honest though, I feel like that approach is actually better almost though, because our clients aren't getting an answer at all. They're getting a no, or they're getting like kind of like a one-word answer. So most of our clients, it is just a paper rejection or a verbal rejection. It's not a meeting, which a face-to-face would be at least their opportunity to participate, which is
right.
So 60 school days. After they obtain parental consent of the summer, it's supposed to be done before the summer, and practically that doesn't always happen. But they have to be done with not just the assessments, but they also have to have the meetings, eligibility and IEP. So it really advise your client to this is time. Okay, this is 3 months. It's not always in their mind because people are like, how could this take so long? 60 school days. It is a really long time, and think about all the breaks and things like that. It adds up, and it can really delay things. And that's why it's really important to make sure that they're not delaying observation or evaluations to do progress monitoring or whatever, because this is already a long time. And so, they have transfer. That's another thing. It'll be a reasonable time if it's a different district. So just keep that in mind. So is assessment rights, appropriate evaluations, and there are hearings over this. There are, whether there was appropriate assessment, and they comprehensively assess in all areas. That's what we talked about. Why I do like to go to the domain meeting, because I want to point out all the areas, because I don't want to go through. I ask for IEs and things like that if I can help it. That's time consuming. And they should be using a variety of assessment tools. They're not just using one test, and sometimes they do, where maybe they're going to say, okay, they've got a 95 standard score on this, and they don't qualify for services because of that. That's not okay. They should be really putting a lot more into it. So it's not just maybe the cognitive assessment or the one academic test. Like if their grades are still low, but they got this score. What's going on? They should be investigating more. There's a lot of other things like native language, and you can look in the regs for that. But evaluations every 3 years or when exited. So if you're trying to discontinue from special ed, they should be. They don't always, but again, they should be evaluating them. So also, parents have a right to request an evaluation. A lot of times, schools will tell our clients and probably other clients, but our parents, but that they, they're trying to look that up. It's not been 3 years. Parents can request an evaluation sooner than that. Usually it's a 1 year unless both parties. If it's under a year, unless both parties agree, they shouldn't be evaluating again. Like I said, because of the test results would be invalidated sometimes. But that between the 1 and 3 years, they can ask sooner. I usually would give reasons why. Maybe they're not making progress is a good reason, or there's a new concern that wasn't evaluated before. Yes.
So if you request this assessment though after 3 years or at the 3 year mark, do they still have to comply with your request to assess, or they can still say no?
At the 3 year mark, they should be initiated before, so it's done before 3 years. Are you saying there's a timeline restart?
I have a situation where somebody has not received an assessment and it's been 3 years and they requested one and the school district said, we don't have to, we'll decide if we're going to do an assessment.
Yeah, no, they. No, it's pretty clear. Yeah, they definitely have to be evaluated every 3 years, and that is a common thing where they'll just do the brief and they'll just do the, like a brief form. So they're just not, they just kind of just do the 3 years, but they don't really assess full. It has to be a full every 3 years. Okay, so yeah, that's definitely a concern. We can talk about that. Okay. They must consider outside evaluation. So a lot of times our clients say, I want to hear this about outside evaluation, I want to meet about it, and then nothing will happen. So they went the extra step and they had this amazing evaluation from a neuropsych that's really helpful and informative, and teams will often be like, it's the same as what we had. They should be meeting with the parents, bringing this to them. And then the right to ask a request for individual education evaluation. I'm going to go on to this next slide. And then right to review evaluations before eligibility and IEP meetings. This is a big part of parental participation, and I always tell all the pro bono attorneys, and I ask for the eligibility, or I ask for the evaluations and things like that before the eligibility meeting, because these things can be really long. These meetings can be really long. So really what you want to do is if you can just kind of get that prep work and review it before, it really, really, really cuts down on time. You can prepare all your questions, and the parent can really participate and understand more. Because sometimes, especially with our clients, it's talking jargon. It's talking jargon for us. And then it's, if it's their first time, they've never been to an LGBT meeting, it's very complex. So if you have that, you can explain it to them and kind of see this is what it says, and this is what we should go ask for, and it's really important for parental participation. So.
Is there a particular amount of advance?
We ask for 5 days usually. There's not. It's usually provided pretty close to it, and a lot of times it'll be draft, just in reality. But but that's helpful too. Just getting that draft. Sometimes they'll hold them side by side and see what they deleted once their supervisor looked at it. Okay. So the IE. So if a parent disagrees with the evaluation, the parent has a right to request an IE at public expense. That request is going to be made to the superintendent. District will then, they must in 5 days, they have to agree to the IE, or they have to request a due process hearing to argue, and they have the burden there to argue that their assessments are appropriate. CPS, that's their policy, they always file due process. So your request IE, know that will happen, but it depends on your evaluation. If you have, some of them are just, and it might be good just to do it and to negotiate it out. It's possible, but some districts they do pay for it. So, and they know that they we had one kid where they blamed he didn't get speech services according to his evaluation because they said he spoke in Ebonics, and that's why he wouldn't qualify. Yeah.
Why?
Ebonics, and and so I thought they agreed to do an IE. So you know what I mean, because it was just the most ridiculous evaluation ever. You're not actually going to get a truth if you blame it on, you know, somebody's cultural, whatever they're saying, whatever she said. Like, I mean, yeah. So they agreed to do it in that situation, and they got an independent evaluator too, and he did qualify for speech services. So, okay, so no right to the IE at public expense if the district has not yet conducted an FIE. So you can't just ask for an IE if they've never done one, right? So that would be a different due process for child fine. It wouldn't be that the district would pay for independent to do it if they decline to evaluate. And if FIE is older than a year old, I saw like a pretty recent case on this, so I don't know if it's everywhere yet, but you know, you can request a new district evaluation if it's a year old. So you know, you don't want to be. I mean, you could try it here. I don't know, but I don't think that would go well. So okay, here you go. The door of eligibility to special ed. Okay. So to be found for eligible for IDEA, it must might meet one of the criteria for at least 13 disability categories in the federal law, 14 here to be an extra one, and it must adversely affect educational performance, and because of that, the child needs special education related services. So here are the categories. Developmental delay. That's the one. That's Illinois, so federal law gives you permission to kind of have this category, and it's before, this would be common for kids from 3 to 9, where they're not ready to label them. I mean, it's a label, that's what they say. And so it's like basically like you know, like emotional behavior, like different things basically that can affect it before they have what they feel like enough information to put an actual eligibility category on. And obviously that expires at 9, and then they're going to have another eligibility and determine. And the most, like I mentioned, the most common are specific learning disabilities, other health impairment, which is ADHD, sometimes emotional disabilities that don't rise to ED level, like, you know, levels could be under OHI too. Also, a lot of districts like OHI because it's not as stigmatized as ED. And then emotional disturbance, it's called still, but, you know, anxiety, bipolar, that's another common one, depression. And like ED is also, it's not just kind of like the bad kids or whatever that have, you know, mental health issues that you think of, but also anxiety. Like I had a client that was 11 and she just cry all the time and she wouldn't go to school and things like that. And she had just, they were really fighting the eligibility. But she had that, you know, she had internalizing anxiety, and it was affecting, it was very, she wasn't going to school, she called 6 hours doing her homework. I mean, so ED can mean a lot of different things, and it's not just kind of what you think of traditionally. And so you know, if you have an eligibility, or if your client wants a certain eligibility category, you know, doesn't go to the next slide, but read the definition of it. Okay, the team does not necessarily go over what the definition is. They should be at eligibility to kind of go through it and have a team discussion, but it's helpful for you to know so you can ask the right questions when they're reviewing all the assessments. So disability category does not equal diagnosis. Okay, so just because your client has a diagnosis outside from a medical professional saying that they have, you know, autism doesn't mean the team is necessarily going to say that he qualifies for autism, which is, you know, I mean, it's kind of wild, but for that one especially. But you know, I mean, I think it's definitely true. So I mean, if it doesn't fall under the legal definition, and then. So the category doesn't always matter too. That's another thing to your clients. So I have some clients that are really stuck on certain categories, and it doesn't necessarily matter. What matters is their needs. Personally, I do like the category that I want because it's kind of contrary to the law, but practically speaking, you know, people are going to look at that category. That's the first thing on the very first page, and they're going to, you know, it does say a lot, especially too with, you know, certain disabilities have very specific methodologies, like autism. Has very specific methodology, and same with learning disabilities. And if it doesn't say learning disability, it says OHI. You know, it's going to be a little different. And not saying that if the IEP can't say their needs elsewhere, but again, people just look on that first page. So I do think it's helpful. And then the same with the primary, secondary, tertiary. You can have multiple disabilities listed. I like it. I like that better than multiple disabilities if I can help it, because I think it's more informative. And also, you know, certain like the private placements, like, you know, if something's listed first, you know, they might not take these much. So, and it must adversely affect child's educational performance. This is actually the big point of contention. It's not about whether you have a disability or what your category is. It's whether it adversely affects your educational performance. And that's kind of what, if you would go to an eligibility meeting that's what you're going to be arguing about. Okay? And so educational performance, and you remember this, and you can inform the team. Tell them I told you, but it's not just academic performance. Okay? And it's not just your grades, your NWE. I don't care about any of that. It's about how it's affecting, your ability to learn and to make, and not just academically, but to, if you're being removed from the classroom because you are having, temper tantrums, or if you're my client where, she's spending six hours on homework every night and she's coming to school tired. That's because she's so anxious. You know what I mean? So there's different ways, and to be creative about it and think about how it's going to affect all these ways. And keep in mind too, the purpose of IDEA is not just so they can function in schools so they be successful adults. And I'll always remind them of that. Okay, so if you just look at the beginning of IDEA, if you look at no other part, just think of that, and that they're trying to prepare you for adulthood and to be independent. And that's the whole basis of the law. So that is the battle, though, and a lot of times they're going to find, they're looking at NWE scores, looking at your grades, but grades can be manufactured. And like we found out in Atlanta, so can standardized test scores. Okay, so just look, and a big part of it too is observation. I always encourage my clients to go in and see for themselves. Yes.
Has LEF ever tried to represent high ability or gifted student that maybe looks okay on paper, but is experiencing a lot of emotional disturbance, suicidality,
Emotional disturbance, yes.
Because they're not being challenged academically in school setting?
Yeah, I definitely have it's average intelligence. The clients that are, sometimes they're actually not gifted, but maybe close to one year, whatever. But yeah, definitely. And my old job, I did do a twice exceptional, they call it, where you're gifted and you have a learning disability. And it's a challenge, let me tell you, because if they can do it, and I've heard my own family members that are teachers, well, they can do it. They can do it. They just don't. And it's it's a challenge. So you really have to, a lot of times when I'm at these meetings, I'm educating the team, and I'm telling them about the law and about what it is, and it's hard though, So it's a very interesting case though, and there's few experts that, this person in my kind of that situation had to go out and she went to Maryland, they did it pro bono to get the evaluation. This is the hoop she went to get her child an IEP, and even then it was really difficult to get the services he needed. And his thing is he's a genius. He's 145 IQ, and he just was really slow at doing it. So he came to the meetings, he's the most articulate boy. It was amazing, but it was hard for them to understand it.
He was
probably smarter than them.
though.
Yes.
He actually had some other.
Yeah, he had a learning disability and he's gifted.
Okay. So nothing, just pure high ability and emotional effects of not being challenged in the classroom. You've never seen anything like that in your life, or at any peer.
No.
No. Okay.
My mother-in-law teaches gifted students, and she has that, but they don't have IEP. So
Right.
They're definitely just socially awkward. They work on social emotional learning there, but it's definitely an angle. If you have a client, we talk about it. Okay, so the IEP is this is the document that we've all been, we're all going to be talking about, right? And so it's a legal document. It includes eligibility areas. It includes the present levels of performance, which is academic and functional, measurable annual goals, services, and it must be reasonably calculated to provide opportunities for child to receive meaningful educational benefit in that space, right? So breaking it down. Okay, so just remember that needs drive the present levels of performance. Okay, so needs, we found those all out, right? At the beginning through assessment, we're finding out all the needs. And then the present levels of performance. We're finding that out from the assessment and from class and from the teachers participating, things like that. But those drive the goals. You don't have that as a need, you're not going to have a goal in it. Let me tell you that. Okay? service, and that drives services. So your goals, you're not going to have a service if you don't get a goal. And placement, you're not going to get a different placement if you don't have the service, the minutes that you need, the services, all that kind of stuff, or the methodology written in the goals. So it all falls into each other. I have had pro bono attorneys go into the meeting and say, my client wants this placement. Like, too bad, too bad. It doesn't, you can't just go in and ask for the end result. It has to be built up. Okay, and it's going to be confusing because you're going to, if you put in your draft letter or your demand letter that you want this placement, that sort of thing. But, it's all about getting the information in there to support everything. And so, it's a challenge. Okay. So the present levels of performance is to be how it affects the child's involvement and progress in the general education curriculum. Includes academic and functional. A lot of times they're just include academic, but functional is a lot of different things. It's behavior, where they're at behaviorally, where they're at, with their handwriting, whatever their needs are. Their speech and their communication ability, anything, physical therapy, like if they're getting DAS-related service, that should be like if they're able to stand up from their wheelchair, if they're doing how far they're walking, if they're using a walker, things like that. There's lots of different things that they should be included in there. And if you want a goal and you want a service in it, again, make sure it's written in there, okay? Make sure, so that's all the data, and make sure it's on data. It's based on data. Oh gosh, I can't tell you how frustrating this is. When you come in and you see Marla struggles with reading. Well, gosh, how am I supposed to write a goal on that? Okay, so ask for the data. Ask for what you need to get that baseline, that goal, or for the you can't. That's not a present level of performance, and so that's a lot of times why I ask for the draft, because beforehand, I'll talk about it later, because if that's what it says, they probably don't have that data. Okay, that's a problem, and so you better ask for that, and so they better at least do some sort of interventions right there, and maybe you can delay the meeting. I don't know, but they I've had to meet several times because of issues like that.
And that would mean that they didn't do an appropriate evaluation, right? Because they don't have
and so
detailed.
And sometimes there is a clue to that for sure. Or they haven't been doing the IEP progress monitor, they haven't been doing things. So, but the struggles reading, that's a real. I've seen that. And so it was a thing where I was like, we had to meet multiple times to get that data, and they still didn't understand. They even had, if you just done an evaluation, they hadn't taken the data and put it into the IEP. And nobody's looking at that evaluation, they're looking at the IEP. Okay, teachers read the IEP, not the evaluation. Yes.
How long should, or I think I've seen, something from the Department of Education about RTI. Like, how long, about not parking children in RTI. What is your thought about how long, if you've got a kid for 2 years in RTI?
So RTI is response to intervention. It's kind of the interventions that they're supposed to be doing under the law to try that basically first, right? They're going to do these general education interventions to step kids up and see if maybe they'll do a medium group and a small group and then one-on-one before they do that. As far as the time limit, they're not supposed to use, like, if a parent asks for an evaluation, they can't use RTI as a reason to reject it. There's not, from what I understand, there's not a clear, time limit. Some of the districts, the teachers I know, said that their school is using 12 to 18 weeks, which is absurd. That's the school year. Then they have 60 days, school days on top. I would like to see a little bit more guidance on that as far as how long the school is allowed to do it if the parent's not asking. A lot of times my parents aren't asking, they're trusting the school. Maybe they don't even know special exists, so I'd like to see more guidance on that. But. Okay, so the measurable goals, and I'm not bringing this up because I think you should go in there and write the goals yourself. Bring this up so you go and know what to look for and know what's wrong with them, okay? Sometimes, if that's what your client wants better goals, and that's fine to go help with that. But sometimes, especially if you're going to be filing for due process, you don't want to fix everything in the IEP because most times it's just fixed on its face. It's not fixed in real life, okay? I've definitely helped with goals a million times because that's what my client wants, and we want to just go in and we want to fix that, and then we're going to monitor the progress and things like that. So they should be, to meet the child's individual needs, to be involved make progress in general education curriculum, and then also to meet their individualized education-related other needs. Individualized, okay? So this is the main thing. Make sure they're not copy-pasted. I've seen other children's names in there. That's a big clue, right? That's not an individualized goal, right? Also, Common Core is a big thing. We've had a lot of debate about it lately. That Common Core standard is just reworded into a goal. Gosh, I can't tell you how not appropriate that goal is. If they're a child that can't add and they're in high school and they're supposed to be doing pre-calculus in that goal. Ooh, wow, that's a problem. Okay, and so you might have to fight the fight. I do it all the time, and maybe they'll have that pre-calculus goal. They won't make any progress on it, obviously. But you can maybe still get the goal that your client really is going to be monitored on. And then they'll actually, maybe that fight will stick in the teacher's mind and they'll remember that they're supposed to be working on that as well. But, and also these goals are, so, okay, I'll stop on that. But make sure they're written for all needs. And again, if you didn't do them, you didn't put that present levels of performance in, if you didn't have that need there, it's not going to be a goal. Okay. This is the thing we all use. This is SMART goals. Yes.
I'm sorry. I just have a question about. I have a child on an IEP, and I feel like there could be 50 goals. She's Down syndrome, so I feel like there could be like 100 goals there. But what's like the normal? And I'm like, I'm like so lucky. We have no issues. We never have. I mean, they do everything we ask. They often prompt things. But under each category, there might be 3 goals, and there's multiple categories. Is that typical, or
No, it's not typical, especially if it's not. I think it's good though, especially if they're keeping. I like goals if they're actually monitoring them and they're doing them and you're seeing the progress and things like that. I don't like too many goals if the services don't support it. But if they do have 3 goals and they only give you 15 minutes of speech, then that's a good way to say why. What are you doing? But I mean, if they are monitoring them, I mean, the more data, the better. I think it's if they are doing it and you're seeing the progress.
So 3 goals, in your opinion, would be a lot, or
for each area?
Per area,
yeah.
They do monitor. I mean,
it's great if they're monitoring, but a lot of times we'll get 1 goal per area. Like I'll get 1 math goal.
Yeah, some things there might be 1 goal, but I mean, they tend to do multiple goals. And in my book, there could be like 100. She's got so many issues that she needs to work on, but and they're very, very specific.
That's great.
I mean, we're at Oak Park. We're so lucky.
Oh yeah.
But
they're great.
Yeah, but I'm just always curious about that. So it's always interesting, sort of the goals that they sort of identify. And I agree, but I could think of 25 more.
Right.
Just how you prioritize those is sometimes the difficulty.
No, totally, and it's true, and that's a common thing that they'll do to kind of argue that they don't need to put more goals, that it's too much or something like that. So, if they are monitoring and they feel like they have the time to do it, that's great. But I'll always argue for more goals if that child has a need, because then those should be getting services to match.
I have a question. I've seen a lot of IEPs that say the child's going to do something 6 out of 10 times or 7 out of 10 times. I mean, is this a percentage gain for them? I don't know what that means. Like behavior goals.
Right.
Child will behave 6 out of 10 times. Like 4 times you'd be bad and 6 times you have to be good.
It really depends on the goal. I'll talk about that in just a second with this end. So specific, make sure they're clear and what the child's going to be doing. I should pass the stranger test if you can't understand it. Like God knows, I mean, nobody's going to understand it. Then the next teacher for a new school, that sort of thing. The stranger thing, anybody should be able to look at it and understand what the child is doing and working on the goal. Measurable, that's kind of what Don's talking about with the 6 out of 10 times or the percentage. It really depends on the goal. And a common thing that I'm asking is saying, what does that look like when you're measuring that? What is this is a funny one I saw when I was kind of preparing for this. A sample goal was Johnny will cross the street 75% of the time. He'll look both ways across the street successfully 75% of the time. 25% of the time he's dead, right? So it really depends on the goal. So it really should be 100% and things like that. If that's what the goal is. But if they're doing 6 out of 7 times, then we need to know what that looks like to collect that data. And I want to see it. Are you doing the discrete trials and doing that sort of thing? So action words. This is a thing student will be able to do. They're getting better about this, but really sometimes I've seen where like student will participate in this curriculum. I mean, they're not doing anything. How am I measuring that if they're just sitting in your class? Realistic, relevant. I think that's what Dan was talking about back there with making sure that there's not too many goals, that it is realistic that they can accomplish this, and they're relevant, that they're working. That's something they're working on right now. And again, if you did the needs, you did the present levels of performance, like you've got all that, then you're going to have that realistic goal. Okay, it's going to be based on that baseline of data. Can I answer during the break? Are you?
It's just reference to the A. Student will be able to. You would recommend that being in the goal like that.
It doesn't have to be the exact phrasing, but it's basically like that they're actively doing something.
Okay.
It could be like I've seen Jen will like read 15 sight words at a kindergarten level. It could be okay, cool. But then you'll also see other ones where it's like Jen is participating in blah 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 80% of that, or Jen. I'm having a hard time, but like you'll know when you see it. When you're like, what are they doing? Like I don't know.
Attention.
Right. Yeah. If it's an intentional goal, that'd be great.
Things like will participate, will improve. Don't detail how they will improve.
Yes, exactly. It should be having like the methodology in a way in there. It's not saying specific methodology necessarily, but it really should say how they're going to be doing it. Time limited. There's two things that are bad. Like the problem areas with this is that it can, we'll see the same goals over and over again. Maybe because that goal is not realistic or relevant. Or it's just like, I can see one where they'll learn 10 vocabulary words. Really, it's going to take them a whole year to learn 10 vocabulary words. So that's an issue there too. Okay. So services, these are all the kind of different ways you need services. And so that's a kind of why, it's not just going to be about academic progress and things like that. But this is all, like sometimes I'll have to fight about occupational therapy because they're saying they can handwrite and things like that, and they're paying attention in class. But what about extracurricular? What about to be educated with all kids? Maybe they're in that small classroom, but inclusion is a big part of the IDEA. And if they need that occupational therapy to work on executive functioning and to pay attention and to function in a regular class or a regular education classroom, that's another angle. So think about that when you're thinking about the different services. The service pages, this is like kind of like my favorite page to look at because it really tells you the most about the IEP. So you have to flip through, I've seen 100-page IEPs before, they're crazy. But you go to that service page and you learn, when their services are, are they weekly, are they push in, pull out. The group and one-on-one, the district here suggests does not list that, so you have to ask if you want that one. You want to ask what that group's working on, that sort of thing. And it kind of does really matter. Even though they don't list it. And then the provider will probably be listed on the goal. Sometimes in some IEPs it's listed on the service page too. Just make sure that person's appropriate. Special ed teachers shouldn't be doing speech services. I've seen it. Social emotional stuff. Maybe if they have schizophrenia, and special ed teachers should not be doing that. Okay, right? Should be a psychologist or a social worker. And this is kind of what I was talking about too with the goals, the 15 minutes, make sure it matches the goals. So if there's a lot of goals, but then there's not enough service, there's a good argument that you can get more minutes. How is she going to do that if you're working for 5 and 15 minutes? How are you going to do those goals? Okay. I only have one page replacement. That's kind of silly, right? But, like I said, if you did everything right, you should be right here, right? So, placement's a set of services. It's not a location, okay? But you can argue for a specific school if their needs, support it. So if they need a certain methodology or they need, a small school, it's possible. So, but that's a common thing you're going to hear. So you're not arguing for that, right? You're arguing for what's appropriate. You're arguing for the services that location offers. So it's appropriate places where they can make reasonable expectation of progress. So that's one thing. If I'm trying to change placement, I'm going to look for a lack of progress. Like I said, that kid, 6 years, no progress, maybe needs a new placement. Okay. You do have that general presumption, and they should, the LRE, keep that in mind at all times. And it is it's preferred to keep them in the general ed environment. But just, you know, a lot of our clients do want specialized schools. And it's a really common request because their kid hasn't been making progress for a long time. You know, I'm probably not going to be sending those kids out if I don't think the facts support it. But, you know, LRE is always going to be, and that's going to be something that the school district is going to argue against. So just be prepared of why they can't make progress, even all the supports have been provided. The team should be considering the continuum placement. On the other side of it, the clients that want to keep their kids in the general ed setting, and usually what the kids are trying to be pushed out of those ED or those emotional, the behavioral problems, right? The kid that bites, the kid that whatever. What have they tried? Do they have a para? That's my first thing. Do they have that paraprofessional, that aide, that classroom aide, that one-on-one aide? They have a behavior plan. What have they tried to keep them in? So, and then, you know, stay put. This doesn't happen a lot, but when they try to change placement and you don't want it, just be aware that you're going to have to file due process if you want to keep them where they're at during the pendency of the hearing. So
This
just
is when the school tries to change the kid without.
well, with you're there. I mean, usually, but you can't always stop them. You know, team decision. You know, special ed director decision. You know, so sometimes there's a disagreement and during the team, and we'll go around and have a. You know, I usually have to poll all of them. You know, see what people think, because maybe that nurse thinks he should go to that different school, or you know, or should. You know, it depends. So that stay put, just be in your mind, and there is like a timeline in there for you know, for all the important timelines of special ed. There's a lot of them. Just be aware that you know, emergency situation, like your client's being moved to a specialized school, and your client was in all gen ed before, and that's, you know, your client doesn't want that. You can possibly stay put, and it's a powerful thing because it's going to keep them in the school, and maybe the district will want to negotiate. And so we're gonna have a break. And so sorry, we're a little over, but we'll get to meetings after this. Okay.
School closings or restructuring. So the school closings everyone kind of heard about in 2013. This year and last year kind of represented students who were either attending a receiving school, had attended a closed school, or there were also schools that were moved into the same building. And those are called co-locations. But any student that has been affected or attended one of the schools that was affected by the closings falls under my project. Some of those cases come in through the pro bono project. So I'll be sending out the write-up usually through Julie or through the email account that you normally receive emails from. But I'm happy to co-counsel a case if you just want to get started with a partner, or refer these cases out generally to everyone. But that's all.
Are you keeping any data on that and putting out any data on that in different schools and how many cases you have, et cetera?
I've kind of been messing with how to organize it is. So generally speaking, like presenting issues, I've been trying to generalize across like receiving schools versus closing schools. There were certain schools where the same issue kept turning up, like certain evaluations had fallen off from certain closing schools to receiving schools. So I'm trying to sort out, especially as this sample size gets bigger, sort out what makes the most sense. I haven't like released anything or but the University of Chicago actually released a preliminary report. It's not really at the student-based level, but they released a report last January kind of giving general feedback about what happened to students, and then this coming December they're supposed to have a follow-up that really has more kind of micro-level data.
They lost like 7,000 students, right?
Right, and we do actually have a student who was one of the ones that just kind of fell off the radar and was lost for a while, but I mean, when that happens, services are discontinued, evaluations are not current, so,
yeah, sorry.
Can I ask a question that I don't know if it's even related, but do you know if when they did these closings, there was any vision given toward looking to the census to see if there really were, what the numbers of children were in those locations when they closed the schools?
like whether or not, so I have tried to FOIA a lot of what the board actually had in front of them when they were making these decisions. My best guess is that they really relied on the 20th day attendance rates at schools. I don't know that they say they have said publicly that they considered census data, but I mean, most of that I think CPS would assert is privileged because it would be just kind of preliminary data and memorandum that they're considering, and they don't have to really release everything that they've considered. And we actually have a school closing law that kind of governs how this process is supposed to work. And census data is not something that they technically have to consider. So I know there were certain schools, especially at the public hearings, that did kind of raise the issue of what population changes had been in their area. So like a lot of the school closings kind of mirrored where public housing had been demolished. So like the students that went from Williams Elementary, Williams Middle to Drake was one where they had been, I forget what public housing had been there, but they had pointed that out at the hearing of like, you have numbers today, but does that really reflect what we're going to be looking at in like the next 5 years? Sorry.
Thank you.
No problem. Thank you.
Yeah, Kate would be, these actually are really interesting because they do have similar issues, like retention and the failure to evaluate and kind of losing kids, losing records. So Kate's a great person to co-counsel with. So if you see these up, you'll see her name at the bottom, and you know, you can either just kind of lead or you can whatever. Cool. So back to it. It's all right. Ashley told me I'm going a little fast, but I am trying to get I am trying to impart as much knowledge as possible. So I really apologize, but there's a lot to it, and you know, if I can give you just a little bit, hopefully I'll help. Okay. So you know, this summary cards speaks to some of our clients, where some of them, you know, they've been fighting with the school for a long time, and you know, they've been frustrated, and they're ready to fight. Okay, there's some, maybe they're just like, you know, they do have a good relationship and they're just trying to get services and or just have somebody to listen to them. It really just depends on the client. Where, you know, I've had clients go in and they want, you know, they want the moon, and then when we get there and they, you know, they're like, please listen to me. I'm not going to do it, but, you know, it really just depends on the client. So just really be prepared for kind of asking about their history, working with the team and things like that. It does depend. So, and this, I've had this client here, and let me tell you, that's a fun IEP meeting to be at. So, okay. So, like I mentioned, the records, we're talking about preparing for the IEP meeting. So the records, this is your discovery, like just this, you know, we don't have, I don't get to do depositions or interrogatories really. So I'm getting that school record and I'm pouring through it, seeing, and we do have a lot of issues. LAF, if you work with us, we do get all the records kind of from the get-go. It's usually one of the first things we do on the case, and we're going to do follow-ups. They never ever provide all the records. But, you know, it's really important to kind of go through these and find tooth comb. We have some, I think we have like the domain sheet in the back as a sample. But like once you start looking at these, they do all start looking the same. You know, so you'll get a better idea of what's available once, you know, you start taking these kind of cases, because and you're just like some fun stuff that you find out later. Like me, I've been doing this for a little while, and then I find out like, oh, they keep this document. And you know, under the law, you actually do have a right to like see the list of what they keep and that sort of thing, what they maintain. But you know, that's not always made available, and so it is fun to see the different databases that they keep and what they say in it. So prepare the client. You know, this is just with any case that you're representing on. Yes. Oh, sorry. That's, I had it up there. So present levels of performance.
Oh, okay.
Yeah. So like I mentioned with the progress, if you're making a placement argument, you know, and you know, or eligibility, make sure like the clock basically, make sure it's accurate. You know, that's a big thing with eligibility. I always check with the client. I'll go take the draft IEP or the assessment, and I'll say, oh, can they tie their shoes? No. You know, I mean, that's like, because they don't, the client knows that's their parent usually. So, you know, they know the best as far as certain things. So it's kind of like, you know, definitely confirm. They might not know, but it helps for eligibility too, and assessment to see if they're accurate. So, I'm sorry, well, yes. So, you know, review the facts of the case and for updates. A lot of times, our clients have been advocating for themselves for a long time by themselves, okay? They don't have an attorney and they're not used to updating an attorney. So maybe they had the meeting without you because they told the client didn't tell you. Okay, that's just part of working with our client, not just like low-income clients, but education, these education cases, because they've been doing this by themselves for a long time. They're not used to reporting to you and telling you. So really just, you have to really hammer home that they need to update you on what the school says to them, write notes, if they email, not all our clients email, but, to really tell you what the school is telling them. The school's not talking to you, you're not talking to anybody, the teachers, anything like that. You're talking to an attorney who's telling you nothing. Sometimes not even an attorney assigned. So everything's coming to the client. So really make sure that they know they can call you and update you. Review, whoops, that's kind of a typo, sorry. But review the goals with the client and then do it again, okay? So it's like I mentioned, sometimes they think they want something, but they don't, or they are listening to what the team's saying. The team will say whatever you want sometimes, okay? But you have to keep in mind with the client what their actual goal is and remind them of that too. You said you wanted a placement. They haven't been making progress. What's going to change now if they added 5 minutes of reading instruction? You know what I mean? So really just keep that in mind and be aware of what they want too. If they do change their mind, that's okay. But just really have a good handle on what your client wants. And talk to the parent about his or her role at the meeting. Again, our clients have been doing this for a long time by themselves. They're used to talking at the meeting. And sometimes it's been really helpful. The client gives an impassioned speech about their child and about what the school hasn't been doing for them for a long time. And I thought it actually helped. It was almost better than what I said, It was amazing. But then I've had some clients shoot themselves in the foot. And just, so depending on the client, now, this is kind of with probably happened to me kind of recently actually, but, sometimes you just won't be able to do it because they have been doing this for a long time. But I do try to prepare as best I can. I have some attorneys say, you don't talk at all. And that's fine. That's, you want to, but sometimes our clients do want to be involved, even if you tell them not to talk. It's still going to happen. So, just really talk about their role and what's going to work best. So, typically, I'm saying I'm going to take the lead. That's what I'm saying. I'm going to do that. I'm, their attorney. That's why you hired me. I'm I'm the one that's going to get mad, not you, right? That's why if anybody's going to get mad, you get to be the normal, sane person. I get to be the crazy, right? So, just letting them know why you're there and that sort of thing because they're not used to it. So, okay. IEP meeting checklist. So when you go over the goals, when you go over the facts, when you go over the drafts, go through and create a checklist of everything. IEP meetings do not go in order. They're all going to be different. Some case managers are great. They're going to start at the beginning. They're going to go through everything. You're like, this is how it's done. Sometimes they're like, okay, what do you want? And they're not going to go through anything unless you go through it line by line. They might not even go through the goals. They might have an annual review where they don't even talk about the goals, unless you make it happen. So that's why you have to have your checklist and you can make sure it's talked about, make sure it's discussed. Because they're saying, we talked about everything. Well, if you didn't bring it up, if the parent didn't bring it up, your advocate or attorney didn't bring it up, then yes. So make sure you have your checklist and go through it with the parent, everything they want to cover, everything that's wrong with the IP that needs to be fixed, that sort of thing. Okay. So at the Okay, so at the meeting, this is a big thing is that team members aren't there sometimes. Even there's a speech therapist that's not at the meeting. Because in CPS or in a lot of schools, they have they're only there like 1 day a week. So if the team meeting or the team day is on a day that they're not there, they won't be at the meeting. So know that they cannot be excused without parental consent. And sometimes they'll just shove that thing right in your client's face and try to have them sign it. And if your client's okay with that, that's fine. But if you are arguing about the total minutes that they're getting, or say there's special education teachers out there, they have to step in. That's not going to be helpful. So maybe you would have to just continue and have them in a different day. But they have parental consent, and they should be submitting a written report before the meeting about what their input is towards the IEP. It's not always happening in practice, but it's something I would ask for if you get the notice of conference and that's somebody that you want to be there. that's necessary, that's providing the service, is not listed, I would be asking for that written report. And if you want them there, they're not excused. Okay, the district and the parent need to decide. So, and sometimes they'll just walk out of the meeting in the middle of it. That happens in the middle too. So they gotta go do whatever. And obviously use your sentence. Like if the nurse needs to go do somebody's feeding tube, like I'm not gonna be like, But if it's something important that's important to your case, then make sure that you exercise that right. Decide your approach. Okay, so I've been to meetings and shadowed a lot of people, and there are different approaches to everybody. You have to do what works for you. Okay, so my approach kind of, I'll tell you, and you can see if you like it, but I start kind of just asking a lot of questions, and I'm not aggressive at the beginning. I am trying to gather data. I don't know. I haven't been in the classroom. It's maybe my first meeting with the client. I don't know what's happening. My client is an okay reporter maybe, and so I'm trying to ask the team lots and lots of questions because I'm trying to figure out what is not in the report. They don't put everything in records. And you're going to get some really honest answers, okay? Teachers are often on your side. They're your friend, They want to help a lot of times. They want your client, the child to do well. But, it's something else stopping them. So, and then maybe, so after I ask all the questions and I kind of get a better idea, then I'll take a more not aggressive, but it, depends on the meeting, obviously. But I'll be much more assertive at that point. And then, obviously, still firm, okay, it's soft on people, hard on issues, right? Because these people, your client has to work with these people for a long time after this. So, we're not going in there trying to wreck everything. Like, you're maintaining relationships while you're doing all this because, this is the team, this is, they are supposed to have a collaborative spirit, that's the idea. And so, sometimes it's fun, sometimes there is some, it's much more adversarial, but in theory it is supposed to be. And I've gotten a lot of, we get a lot of things too by, having the great facts, but still being great, and, still having a good relationship with people. So you're working with the same attorney a lot of times too. It's the same people going through. Okay. Like I said, ask a lot of questions and make sure the person you ask answers. A lot of times somebody else is going to jump in, like the case manager or the principal. They don't know the student, Who knows the student? Teacher, right? Teacher knows. You're asking that teacher, how are they in their reading? Case manager shouldn't be answering, okay? Your client does have a right to that information. Part of the meeting. So make sure you're taking lots and lots of notes. Obviously not notes over advocacy, okay? I've definitely had that happen too. So, when participants leave, like I mentioned, and then also like personal requests and the team's response. So get the question, answer, that sort of thing. Yes.
So there's no official minutes or records of these meetings?
Some teams do take minutes. They
those
really
get distributed to everyone. And
yes. So that is part of the record, and you have a right to that. But that's what the minutes are is the IEP. And so I'll kind of get to that too. But I think, I take lots of notes, and then obviously if we don't disagree, or if we don't agree, there's going to be a very detailed record. Yes?
You also should realize that if the school's taking notes and putting them in the IEP,
yes.
they're putting notes that they want to put in the IEP.
Yeah, exactly.
So admissions or statements that you want to make sure you remember and write down is really up to you.
Right, exactly. And so, they're going to phrase it how they want too. So, like, parental, there's a section called like parental,
notes.
Huh?
Parental notes section.
No, the, concerns, yeah, sorry, blank. And I've seen those, client, parent wants Johnny to keep making progress. Is that what you said at the meeting? No, like, you know what I mean? So, they do them definitely right. Actually, it's completely right. They write what their perception of the meeting is and what they want to say. But
a lot of times
yes.
I have a special ed teacher in the room, whether it's an inclusion classroom for the child, the teacher, when I taught math, may not be in the room. A math teacher might be there, but not the actual student's teacher.
It should always be the student. Yes, that thing happens in practice, but I'm not having a meeting with somebody doesn't know the student.
That's what I saw at CPS.
Oh, yeah,
How
me
would you
too.
prevent that?
Huh?
How would you prevent it?
I said we want reading
we want
teacher.
this teacher there.
Yeah. Let's bring
Can
this
you
up.
go back to Julie's earlier slide that lists who are the members of the multidisciplinary team and who's required to be there?
Yes.
Which she indicated with asterisk.
Yeah, so you're gonna want, yeah.
So if people aren't there, tell them you're not having a meeting.
Right. So that's page 9, slide 18. But yeah, that's it's like the parent, somebody that has to make decisions. I probably should have doubled the slide on the other one, but it's basically like you definitely need a decision maker there. That's for sure. If you're thinking about who needs to be at the meeting, I mean, you're not going to get placement. You're not going to get anything that costs money. You're not going to get if there's not a decision maker there. I mean, they have to be when they're by law, but you're not going to get it.
Your note says general education teacher. Does that mean the general education teacher?
That's just the basic requirements under the law, but you can your right to information. That's how you're getting people into.
Like a high school student might have 7 teachers. And maybe
they're going to bring in
employees.
like whoever's least important. That's how it usually starts. But you're bringing in people that you need. So if they're writing a math goal and they get special, so they have a special ed teacher, but then they need a special ed teacher that teaches math. Or if they have a general ed teacher and they have maybe a goal that's going to be happening in general ed, it should be the teacher that's going to be executing. That's not going to be the band teacher or the gym teacher. It depends on the kid's needs. But
what I was trying to say is that
yes.
when they talk about math goals,
Mm-hmm.
I as a math teacher was there. I wasn't necessarily the student's teacher.
Right.
Somebody else's.
It should be somebody that's participating should have knowledge of the student. That's
And they were
part of being a
saying,
team
as
member.
long as you have an idea of the math, I always thought it was a problem.
It is a problem, and it's not supposed to be. You're not a member. I mean, you're not supposed to be like if you don't have knowledge of the student. Yeah. I mean, it's not just saying right anybody willy nilly. I mean, okay. So let's see. Oh, there's no time limit for IEP meetings. I put this in here because I feel like a lot of times, they're ready to be done in an hour, or if you're not done, you haven't covered everything. Well, it's done. You meet again. And this is something like, especially when I first started doing this, they'd be like, okay, it's finalized, or your parent will sign a consent to proceed, and I'm like, what is any of this? Is there time? And there's no time limit, right? If you're not done with it, you meet again, and that sort of thing. So, and it's necessary sometimes, like I said, if they don't have the present level of performance, or if the goals are still screwy, and you have to kind of go through them. So, obviously it would be reasonable. You're not going to meet 15 times about it, but they just can't just, it's over unless you talked about everything. You don't agree, then that's a different situation. But yes.
Have you found in your experience that because the parent is showing up with an attorney, that the school district will also have an attorney?
Oh yeah. Not within the big district, because I don't feel, or CPS, because they're not like staffed with enough attorneys. But the suburban districts are almost always the attorney there if you're there. Even when they don't think it's contentious, they're like, well, you're gonna be there? Well, I probably should be there. I don't know. But yeah, so it's definitely in the suburban district. CPS, you'll see somebody that's called a diverse learner support leader, sometimes in place, and it's not an attorney. But they're like the compliance officer.
What are they called?
DLSL is what we call them. They're diverse learner support leaders. Again, they're not attorneys. There's a couple of them that are like attorneys, but they're not attorneys in their job. They're like compliance. They're supposed to support the team. They're really like, they're kind of acting as the person to do the compliance and things like that. So it's
School session?
CPS. Yeah. And so, again, I mean, but they're not attorneys, so it's like, you can't. We always see there's like we always see CR, the attorney for CPS and things like that, but sometimes that's who you're dealing with because they got 5 attorneys now, so for that district it's pretty hard. I mean, it must be busy. Okay, so after the meeting, at the end, you're triple checking that IEP. Like I said, it says things that you don't think happen, right? Or what you all agreed to, or what you think you agreed to. Am I gonna say that, right? That goal might not be, and they're like, okay. And they're like typing, you think it's happening, but some schools will post it up on, you can see it happening, and I love that because I think, I say this all the time. But, sometimes I'll sit there and read it afterwards, and I'll be like, change this. But sometimes you even email afterwards and change that, and, take That's why you're taking notes on what was agreed to, too. Changing the wording on things that aren't representative of what happened. Okay, and not signing the 10 days to implement, especially if you haven't read it, it's not going to make the IEP not happen. It's going to happen in the 10 days, unless it's like initial eligibility. That's the only time the signature really matters. But, especially the placement, stay put, obviously is really, like I mentioned, make sure that kid stays in the place if you disagreed on that. Okay, walk away with finalized documents. Oh, please. If you do anything, don't just go, okay, I signed that, my parents signed the consent to proceed, and then they get to change whatever they want, right? That's what that consent means. I don't like to do that anymore. Because you have to have a lot of trust. But walk away with the finalized documents that are complete, because, you don't want to get it in the email. You might not get it for a while, or something like that. And that's been happening, too, where then you don't have a chance to review it, obviously. They say, oh, our printer doesn't work, or something like that. Well, find a good printer, Email to me right now. I'll see it. So, and everything that was done that day, everything that was signed, evaluations, if you want protocols, if you want anything they flash, that's one of my favorite. They just hold something up, it's like, oh, this data, get a copy right there. It's not gonna, you're never gonna see it again. Okay, so monitor progress after the meeting. If you're still involved in the case, or advise the client to if you're not involved. You kind of went in, got the speech services, and that's what your thing was. And you're closing the case, I'd still advise the client too, but if you're still monitoring and working with the client afterwards, you really want to be asking for the corresponding data, the IEP report cards. A lot of times, like I said, the IEP says one thing, what do they have? They don't have anything to show it, okay? So that's really why you want to make sure it says that. I'm 10 minutes left, so I gotta go through. Okay, disagreement, IEP, dissent. This is something that, it's just basically we use to kind of say everything that happened, everything we disagree with, and it's just a good way to put it in the record. So, kind of support your testimony at the end of it. Resolution. So here's the procedure safeguards in place. I'm going to talk about administrative due process hearing a bit, state compliance complaint, and the OCR complaint a little bit. The two at the bottom, state-sponsored mediation can be part of the due process. We also do just mediation only sometimes when we have something really clear. We've kind of talked a little bit, but there is some court stuff happening, but usually it would be, administrative period of appeal, or your complaint with the federal, or it's Ezra, which we're usually doing, so we're doing a lot of record stuff. But okay, the due process. So we just call it due process, but it's trial-like administrative hearing. There's cross-examination, there's direct examination, opening, evidence, but it's like the evidence rules are they're supposed to be much more lax. They favor getting information in. And that's, because it's the administrative process, and you don't have discovery, and so it's important to kind of get the information, and that's why it's a little more relaxed. But they do still follow the rules of evidence. I say to resolve major disputes. This is not agreed upon by everybody. Some people just file due process. They feel like it's easier. They're more familiar with that. They're lawyers. But, IEP process, we have some, like the private attorneys will send the parent to the IEP to deal with, and then they'll do due process, and they'll say parent report back. That's some way people do it. That's fine, Typically our parents, we're doing it through the IEP process, but we definitely have due process cases that come through as well that need representation. Okay. So it's resolve disputes between the school district and the parent about identification, evaluation, educational placement, all the stuff we just talked about. Whether the substantive claim, which is free appropriate public education, whether that was provided to the child, or the procedural errors. Some of the things we talk about, like notice or child find stuff like that. Whether it requires a denial of FAPE, basically. Impeded the child's right to FAPE, significantly impeded parental participation, or caused deprivation of educational benefit. We have 2 years from the date the parent knew or should have known for the basis of the complaint, like the statute of limitations. And then the burden of persuasion here is the filing party. That's a U.S. Supreme Court decision. So, and that's always going to be the parent, almost always, really, because the parent's the one filing. The time when it is the district, because usually, i.e., you file an IE, they're going to file against you, like I mentioned earlier, or maybe the parent, this is kind of rare, but doesn't provide consent for evaluation, the district can file due process against them. So So I don't see a lot of cases like that, but the IE one, yeah, the district will file. And so they would have the burden of persuasion. Burden of production in Illinois is always on the district. They have to provide, or they have to produce evidence to say there's a prima facie case that they provided FAPE. So they're in control of record, that's why. So even if there was kind of a case I saw recently where it's basically like the district put on, you know, the parents filed, and then the district was like, that's not enough. And they didn't put a case on, okay? They had their burden of production, so they had to put something on, say that they provided FAPE. So that's the burden of production. Okay. The complaint. So you're sending it to the superintendent, and we send a courtesy copy to ISB, also for their attorney. I mean, obviously, courtesy copy, but actually, have it be served is the superintendent, or we just walk it over to CPS. We're so close, but if you're doing the one with us, I'll just walk it over. Okay. The name of the child, address is what's required to be part of it. You're supposed to plead with specificity. Okay. So we'll write it in like a form of a letter, but we're still putting in all the facts in like you would do in a pleading. If you're alleging the facts that are going to be supporting your claims. And then the proposed resolution, so this is your relief requested, what you're asking for. You know, you can be a little more vague at first, but you're going to have to be much more specific when you get to hearing. They want to know numbers as far as minutes of what you want, what placement you want, you know, specifics. Obviously, you cannot raise claims at hearing that are not alleged in the hearing request. You can't just be like, here's an extra claim. You have to have it in. So, and then this is something like, oops, you may waive claims elsewhere, like at 504. That was kind of one of these things you could allege or waive claims, if not in your due process, even if they don't have jurisdiction. Kind of a weird thing. So here's the due process timeline. I also have the there's like a chart in your manual. Here's a little handy dandy, but it's like basically, you know, this starts it, and then they're going to appoint the hearing officer within 5 days of the hearing request, and then you have 5 days once the appointment to strike a hearing officer, and the role of that